Hi, I'm Victory Thiru. I'm a solicitor in the Housing Department, Anthony Gold. I'm joined here today by my colleague, Eleanor Kyle, who is a solicitor in the Housing Department. Today, we'll be addressing frequently asked questions that we hear from clients about their rights relating to disrepair.
So the first place to look to find out what your rights are is the tenancy agreement that you signed at the start of your tenancy, or the most recent agreement that you signed with your landlord if you've been there for a long time. Most tenancy agreements will set out express terms that deal with what your landlord is obligated to repair, and also what tenants are obligated to repair. Also, if your landlord is a council or a housing association, they may have a tenant's handbook, which will set out in some more detail what they will and won't repair, and that can normally be found online. If your tenancy agreement doesn't mention repairs, or if you don't have a written tenancy agreement, then there will also be repairing obligations that are implied by the law. And that will be under the Landlord and Tenant Act 1985 or under the Homes Fitness for Human Habitation Act 2018. And both of those pieces of legislation imply additional terms into your tenancy, regardless of what it says in your tenancy. So I'll look at those acts in a bit more detail. The first is Section 11 of the Landlord and Tenant Act 1985. And this section will apply to nearly all tenancy agreements, including those that don't say anything about repairing obligations. And this section says that landlords should keep in repair, number one, the structure and exterior of your dwelling house. And this will include external walls, roofs, internal ceilings, drains, gutters, anything that is structural in nature. Number two, your landlord must keep in repair installations for the supply of water, gas and electricity. And for example, this will include basins, sinks, baths within your property. And number three, your landlord should keep in repair installations for space heating and heating of water. And that will include boilers and radiators. So these obligations cannot be contracted out of your tenancy agreement. And so then moving on to the second piece of legislation, which is the Homes Fitness for Human Habitation Act 2018. Again, these obligations apply to most tenancy agreements. And the focus here is to address issues within your property that might pose a risk to your health and safety. So they go slightly beyond the repairing obligations that you find in the Landlord and Tenant Act. This is a relatively new law that's been in place since 2019 and for some tenancies since March 2020. And this law says that your landlord must ensure that your property is fit for human habitation at the time that he grants you the lease. And then your landlord must also ensure that property remains fit for human habitation while you occupy it. Under this law, your landlord may be in breach of the obligations if there are issues that pose a risk to your health and safety, such as serious damp and mold, electrical hazards, or environments that allow excessive cold or heat within the property. It might be one of those issues, or it might be a number of those issues together that make the property unsafe. And so this legislation can be very helpful. The law says that your landlord will become obligated to carry out repairs once they've been notified of an issue. So the obligation only starts once you've notified the landlord of the issue. And after that, they should carry out the repairs within a reasonable time. So a few things to note then in relation to your repairing obligations. As I've said, the obligation only arises once your landlord is notified of the issue. What is a reasonable time for your landlord to carry out the repair will depend on the nature of the repair itself. For some issues, they will need to be looked at urgently and should be completed within 24 hours. For others, it might not be unreasonable to wait several months for the repair to be done. So it will vary from issue to issue. Number two, these repairing obligations relate to disrepair within your property, and disrepair is when an issue or an item within your property falls into disrepair, and that's when your landlord is required to come in, address the situation and carry out the repairs. it does not extend to your landlord making improvements to your property. For example, putting a radiator in when there wasn't one there previously, and that would be classed as an improvement, and these obligations on the whole do not extend to requiring your landlord to carry out improvements. And finally, these repairing obligations will also apply to common areas within your property that your landlord also has control over. So for example, if you live within a block of flats or a converted property, and your landlord also has control over the hallways or the entrance foyer or even a roof terrace, these repairing obligations will apply to those parts of the building as well.
In order to determine your rights as a leaseholder when it comes to disrepair, you would need to refer to the terms of your lease. If you don't have a copy of the lease, you can normally request it from the land registry. The freeholder's obligations to repair are usually dependent on how the lease is written, but it is common to find a term containing an obligation for the freeholder to maintain and repair the structure of the building. In general terms, the structure of the building refers to the foundation, floor, ceiling slabs, roofs, and exterior walls. You also often find a clause in the lease referring to the freeholder's obligations to repair the downpipes, guttering, soil pipes, and the communal areas. The communal areas are part of the building that are shared, such as a corridor, door entrances, communal rooms, lifts, and garden spaces. As well as the terms included in the lease, there may also be additional obligations implied by law. Their application will depend on the specific circumstances of your case. You may need further advice from a solicitor.
So as we've covered in previous videos, your landlord will only be obligated to carry out the repair once they've been notified of the issue. So the first step will be notifying your landlord once you notice the issue in your property. This can be done either by phone to a general repair line, directly to your landlord or to your housing officer. You could also do it in writing by email, text message or letter, again to general email addresses or to a specific housing officer. And you may also want to report it in person in the housing office or again to a housing officer when you see them. And any of these methods are valid for notifying your landlord, but when you are reporting it either by phone or in person, it's a good idea to keep a separate written note of when you have reported the issue and what you have specifically reported, just in case the report is lost from your landlord system for any reason. For some issues, it might not be straightforward for your landlord to come in and do a repair, and in those situations, it might be best to ask your landlord to come and inspect the property and to assess the issue themselves. If you are asking your landlord to carry out an inspection, it's always good to keep a written record of when the inspection takes place, of who has come to carry out the inspection, and of any comments that they make while they're looking at your property. They may also discuss with you the works that they're going to recommend, so it's useful to keep a note of those as well, and where possible follow up by email with your landlord after the inspection to confirm what was discussed and what works were proposed. It's also useful to take photographs at any opportunity, both when you first notice the issue and also if you notice any further deterioration after you've notified your landlord, and keep those photographs and also provide them to your landlord as part of your record keeping. Finally, what do you do if your landlord doesn't respond to you notifying them of an issue? There's a few steps or a few routes that you can take. The first is to make a formal complaint to your landlord. Most landlords should have a formal complaint procedure that is set out in writing, and you can follow that procedure. If you have a private landlord, you can report them to your local council if it's an environmental issue. You could ask for an environmental health officer or the local authority to come and inspect the property if you are particularly concerned about an issue that's not being addressed. Another option is to speak to your elected representatives. Both councillors and MPs can often be of help in getting long-standing disrepair issues dealt with quickly. Another option is to report the issue to the Housing Ombudsman. it will be necessary for you to have exhausted your landlord's complaint procedure before you contact the Housing Ombudsman. So as long as you have done that, made a written complaint and received a response from your landlord, then you can also make a complaint to the Housing Ombudsman. They then may be in a position to investigate and to carry out some negotiations between you and your landlord. And then the final step, if none of those routes have enabled you to get the disrepair sorted, another option is to seek legal advice. And you can do that through your local Citizen Advice Bureau, or you might want to contact a housing solicitor directly and get some advice on your rights and the legal options that are available to you. If you have had a long-running disrepair issue that your landlord has failed to investigate or address, you may seek legal advice and decide to bring a legal claim against your landlord. Any legal action will need to be supported by good evidence, both of the disrepair and of your landlord being notified of the disrepair. And so it's important to collect evidence from very early on in that process. Firstly, you'll need evidence of the issues. So that might be photographs or videos of the disrepair. It's also helpful to keep a note of the date that the disrepair started in your property or when you first noticed it, and also the dates when you noticed any deterioration in the issues. If any inspections are carried out by your landlord or a surveyor on behalf of your landlord, it's helpful to keep any reports that you receive following those inspections, or keep a note of any works that were carried out or recommended during those inspections. And it's also helpful to keep evidence relating to any damage done to your own possessions as a result of the disrepair. So for example, if you've had any items of furniture damaged by the disrepair, or you've had to purchase any new items to replace those that have been damaged, it's useful to keep both documentary evidence of the damage and also evidence of any costs that you've incurred, so any receipts relating to that. Secondly, it's important to keep evidence or collect evidence of the notice that you've given to your landlord about the issues. So this could be copies of emails, text messages or calls to your landlord reporting the issues, or any complaints that you've raised with your landlord about issues not being addressed. If you're discussing issues with your landlord over the phone, it's helpful to keep a note of those calls, the date and time of the call, and also anything that was discussed, any works that were agreed, or inspections. If you have any inspections carried out to your property, it's helpful to keep a note of those as well. Helpful information will include the date that it was carried out, the name of the individuals carrying out the inspection, any discussion that you had with them while they were in your property, and any proposed or agreed works or further investigations. You may also want to ask for information from your landlord, and you can do this in a number of ways. You can contact your landlord yourself and ask for evidence relating to your property. You can make a freedom of information request as well. If your landlord is a local authority, then you can make this freedom of information request directly to them and ask for copies of your repair records or any other documents that relate to your own property or the building that your property is housed within. If your landlord isn't a local authority, you can still make a freedom of information request to your local authority about the building that you live in. You might want to contact the Environmental Health Department of your local authority and ask them for relevant records as well. And if you want more information about how to make those requests and the types of documents that you can request, there's a lot of information on the ICO website, and that's the Information Commissioner's Office. Another way to obtain information from your landlord is to make a subject access request. Freedom of information requests are limited to public bodies, but a subject access request can be made to any landlord, even if they're not a public body or a local authority. And so you can make a subject access request to obtain any documents that contain personal information about you. And that's also a helpful thing to do in order to prepare for legal action. Finally, one thing that you might want to do is speak to your neighbours in your building or along your street and to see whether any other properties have experienced similar issues. You might want to collate evidence together, both of when the issues began, how extensive they are in the building, but also when your neighbours notified the landlord of the issue. Because for some issues, that will be sufficient notice for your landlord to have addressed it for you as well. Similarly, you want to look at getting photographs and videos of the issues, evidence of notice both in writing or notes of phone calls, and any costs that have been incurred as a result.
The main aim in taking legal action is to get a court order compelling your landlord to carry out repairs and to recover compensation for having a home in disrepair. Most cases do settle out of court where there is an agreement for repairs and compensation. In terms of repairs, if you choose to instruct Anthony Gold, we would instruct one of our trusted experts to produce a report on the condition of your home. The report would include details on the various defects in your home, as well as a list of recommended works to remedy the defects. In terms of compensation, this is normally divided as general damages, which is compensation for inconvenience and distress of having a home in disrepair, and special damages, which is compensation for out-of-pocket expenses that you would have incurred. General damages is calculated differently depending on whether you're a leaseholder or tenant. As a general rule, general damages for tenants is calculated as a percentage of your rent for the period your home was in disrepair, although a global sum is sometimes awarded. For leaseholders, it is normally calculated as a percentage of the average market rent. This means that we would look at the average rent for a similar property in the local area. For example, if you had a 2-bedroom flat, we would look to see what the rent is for a 2-bedroom flat in the local area. Special damages includes your out-of-pocket expenses that you would have incurred due to your home being in disrepair. A non-exhaustive list would include damaged furniture, damaged electronic items, contaminated food items, damaged clothing, and shoes. The question of whether you have a valid claim depends on the facts of your case. The key point to note is that you would need to prove that each item claimed is connected to disrepair in your home. We at Anthony Gold will be happy to assist you with any questions you may have.